Again, welcome to everybody who's attended. Well, I see we're now up to 44 people. A lot has been happening in the field of non-recent sexual abuse cases. There have been two Supreme Court decisions in the last 2 or 3 months, a number of other important cases. FZO has reached the Court of Appeal, and there have been at least, by my count, 4 High Court trials. BXB, DSN, EXE and FXF, in 3 of which, in fact, I represented the claimant. The other speakers today probably need no introduction to you from me. Patrick Sadd, who's going to speak to you first about where we are with limitation, was lead counsel in both the independent Jersey Care Inquiry in 2013 to 16 and in the ICSA investigation into the sexual abuse of children in the Nottingham councils a little later. He has wide-ranging experience in historical and present-day abuse claims, full range of settings, religious institutions, schools, care and foster homes, football clubs and the like. And recently he's been advising on the impact of pool and CN on failure to remove cases. And then you're going to hear from Paul Livingston, who's going to tackle vicarious liability. Paul is currently instructed as junior counsel to the independent inquiry into child sexual abuse and has been junior counsel to the inquiry on 3 different strands. First, the child migration case study. Secondly, the children in the case of Nottinghamshire Council's child. And currently, I think, and slightly postponed now, child sexual exploitation by organised networks. He was previously junior counsel to the Jersey Child Abuse Inquiry as well, and specialises in employment and discrimination law. Before we have questions at the end, I'm then going to talk to you briefly about those recent High Court decisions, what we've learned in particular from BXB and DSN, and also just to touch on 1 or 2 useful tips, which as claimant lawyers, as I think we mostly are, we may be able to take advantage of arising out of the judgments in those cases. So let's get started. I'm going to pass over to Patrick without further ado. Thank you very much.
Hello, and thanks for joining us, as James says, for this series of short, concentrated reviews on generic issues affecting the abuse cases you're currently working on. I've chosen to do a run through on limitation, and you may ask why now. Well, a fortnight ago, on the 12th of May, you may have seen drop into your inbox a new posting from the BLM Abuse and Neglect blog on limitation and sexual abuse, and it was compiled by Genevieve Rich. The post provided a table of recent cases, 12 in total, the first in 2015, and 5 of which, on my calculation, are from 2020. The table is divided into 6 columns: name of case, age of claimant at time of abuse, period of delay since abuse, delay since primary limitation expired, whether recent criminal trial, and whether discretion exercised. And so you can have the names of the cases readily to hand. Ada Temple can forward the posting to you after this webinar, as well as the citations for other cases that I'm going to mention in my review. I thought it would be interesting in this 20 minutes to see from a review of the 12 cases what practice points come up and what needs to be added to your checklist, if anything. It may be that this will give you the reassurance that you are chasing down all the key issues. Of course, we all operate still under the 1980 Act, and we're all still waiting to see what the ICSA panel will recommend and whether, in fact, England and Wales will follow the Scottish lead. The last ICSA hearing on limitation and redress was on the 5th of February this year. I gather that the MOG's representative was being a bit yes-ministerish about it. That is, she told the panel that if they were to recommend legislative change, the MOJ would consult with interested parties, which is a puzzle, given that the same interested parties have given evidence to Alexis J. and her panel on the very issue at hand. Maybe she will be sent a copy of the report when it comes out. So for now, the 1980 Act is what we all work with, at least in the immediate legislative term. And if you need reminding, it's the criteria under section 33(3) of the Act that the courts work through, and primarily, certainly in these 12 cases, evidence and argument going first to the reasons for C's delay, and second to the evidential prejudice to D caused by that delay. Does one outweigh the other, although they are not direct corollaries? So what have I picked up? Well, first, there is nothing new really, but there are some very good examples of approaches in practice and some very clear accounts of how section 33(3) works. Second, what emerges is that prep on limitation issues is labour intensive. All the cases underline the need to investigate as fully and as thoroughly as possible your client's reasons for delay. Already difficult enough for them in giving a statement on what happened, but where limitation is at large, it remains crucial that time is spent in forensic detail on what has happened since the abuse. The benefit of doing so is well demonstrated in many of these cases. Third, the cases show a truism for you in gathering evidence and for James, Paul and I as advocates. You can't make the evidence better than it is, however frustrating that is. Fourth, avoid every time, if you can, a direction that limitation be tried as a preliminary issue, except perhaps in a weak case, but then you'll probably not be taking that case forward anyway. In the 12 cases under review, only 2, RE and GE, Wild and Coventry, were decisions on preliminary issues. Why do I say avoid? Well, you'll know from the stable of cases from 2000 and before 2015, I should say, the 2009 Raggett decision is a good example, that a judge hearing all the evidence gets a complete view of the case. I don't suggest that judges are not able to assess limitations separately from substantive issues as they're required to do. Good examples from the BLM table include the cases of BXB and Watchtower, FZO and Haringey, RSL and CM, LXA and Wilcox, and DSN and Blackpool. But a trial can establish a favourable impression of the claimant, and that matters in these types of cases, although of course the risk is that it can go the other way. In the 2017 Wild decision, the judge puts it in this way: what is important in a preliminary hearing is to form a clear view of the likely issues at the contemplated trial. But what the preliminary hearing lacks is how the issues identified actually come out in the evidence at trial. The October 2018 powerful factual case of RSL and CM has the judge, in my view, merging limitation with substantive issues, perhaps understandably given the facts. A perpetrator seeking to go behind his victim's evidence at the criminal trial 9 years previously when he was convicted of her rape as a child. The judge makes an overall finding that D had come, quote, nowhere near to proving the allegations made by C are false. C has been consistent and convincing. That she was able to give such evidence in such a calm manner when facing the person who abused her so terribly is very greatly to her credit, end quote. And then later, when considering the effect of the delay, the judge says, I also bear in mind the strength of the claim. It is a very strong case, end quote. Has there been intermingling here? Does it matter? Have a read of the case and decide for yourself. It's worth a read, whatever, for a whole raft of reasons, not least a perpetrator trying to go behind convictions and the judge's review of the crippling effects of abuse on a child. The April 2020 decision of FXF and Ampleforth shows, of course, that a full trial can go the other way. In this case, the claimant alleged sexual abuse when she was aged 4 or 5. By the date of issue in 2017, 32 years had passed since limitation period had expired, and C was now 56. After a 4-day trial and in a dense and lengthy decision, the judge dealt first with the limitation issues on reasons for delay and prejudice to the defendant. As with the RSL case, the judge in FXF articulated the importance of resolving limitation and substantive liability issues separately, and the self-regulatory maxim, don't decide liabilities issues before deciding limitation issues, and crucially, keeping in mind what the impact of the evidence on the case that might have been available to D and that can no longer be adduced would have had, evidence that could not now be tested in this case. The prejudice was so substantial that the reasons for the delay could not temper its prejudicial effect. And having found that C failed on limitation, Mrs. Justice Lambert ends the decision abruptly. On the list of cases, on the list of go-to cases, I should say, to review when assessing limitation in any one of your current files, and regularly relied on in these 12 recent cases, are still KR and Bryn Allen, from where the cart before the horse metaphor is taken, A and Hoare, on the prejudice caused by a claim coming out of the blue, Kane and Francis, relied on by the judge in RSL and LXA, what is actually meant by is a fair trial still possible, and the 2017 recent decision of Carroll and Chief Constable of Manchester in setting out conveniently the court's limitation checklist up to that date, as well as a reminder that the burden on the claimant is not necessarily a heavy one. That phrase, a fair trial, comes under critical scrutiny in what might be read as a hard and robust decision of the Court of Appeal in RE and GE. Lord Justice Leveson sees the long relied on fair trial catch-all as just too easy an approach. Yes, the possibility of a fair trial is necessary, but it's not enough to disapply the limitation period. It is, quote, by no means the end of the matter, end quote. What matters is whether it would be equitable, that is, fair to C and to D, and he suggests fair in the broader sense to public policy issues on the finality to litigation. This is repeated in the 2017 decision of Wilde, quote, even when a fair trial remains possible, the overall circumstances may lead to the court in the exercise of its discretion to refuse to exclude the limitation period, end quote. What, we might ask ourselves, would be such overall circumstances? Is it just a way of the court knocking out what it sees as a stale case? Perhaps the most important takeaways in reviewing the BLM table are what the court considers good reasons for delay to temper prejudice. Of course, these cases are necessarily fact-sensitive. To get to that point, a detailed statement from C is, as I mentioned before, I think vital. Here are some examples of what the court considered good reasons for delay. 2015, GE, 21 years delay, wanting to protect family members from disclosure. Yes. Wanting to make success of a relationship? No. 2018 decision of LXA, 22 years delay, understandable reluctance to disclose matters of intensely personal and intimate nature, quote, good reasons, evidence still cogent, there was a criminal trial. As to financial losses, it was more difficult, but, quote, judges are used to doing the best they can. The 2018 decision of RSL, 9 years delay, and by the way, the one I mentioned a moment ago, this is the one decision to read if your time is short. There are a raft of practice points. Those aside, the decision articulates the reasons for not disclosing as a child, risk of calamity, shame, fear, and as an adult, not being believed. It's a particularly compassionate decision in the canon of abuse cases. 2019 decision of Young, not directly an abuse case, there a 15-year delay, the reason awaiting outcome of the criminal trial, which then collapsed. Only then did C bring civil proceedings. That the court felt was sufficiently delayed, as sufficient explanation, I should say, of delay. 2020 BXB decision, 24 years, humiliation, upset, shame, not being believed, not raised again. Quote, I see no reason why that should not count as good reason for the purpose of the statute. Nothing in the statute to say that the only good reason has to be diagnosed psychiatric disability, end quote. C had managed to avoid any concentrated focus on the rape, and justifiably so. In the 2020 DSN decision, about which you'll hear James speak, 22 years delay, judge accepted the reasons why C could not disclose, quote, would require him to disinter toxic memories from the place where he had buried them, end quote. And applying Hoare, C had been, quote, disabled from commencing proceedings. In the 2020 EXC decision, 24 years delay, shame and reluctance, anxiety, good enough for delay. And then what the court considers prejudice sufficient to meet justified delay. In Wild, 29-year delay, loss of documentary evidence affecting cogency of oral evidence. Murray, 2018, 34 years delay, no documents, so acute difficulty, said the court, in resolving vicarious liability and in assessing quantum. So what's the real take for us here from the VLM limitation table? Well, as with everything you all do in this area of practice, attention to detail on limitation issues remains absolutely critical. Thanks so much. And now we can go to Paul on vicarious liability.
Thank you very much, Patrick, and thank you all for coming. Just a quick reminder that if anyone has any questions, then they can put them in the chat box, and I will put them to Patrick and James at the end. So I'm going to talk about vicarious liability, and as you might remember, Lord Phillips had said in the 2013 Christian Brothers case that vicarious liability was on the move. In my view, the recent Supreme Court cases suggest that it's likely to continue moving, particularly on abuse cases, but not necessarily in one direction. You might ask whether it's more likely to move now in the direction of Barnard Castle, to which I'm afraid I have no answer. So, the background to the law on vicarious liability. Now, at a very basic level, vicarious liability involves imposing liability on an organisation not because there's any fault on the part of that organisation, although there might be, but because we require that organisation to shoulder the burden. And there's numerous policy reasons that have been developed almost since medieval times and have been recited, I thought, helpfully in the 2013 Court of Appeal case of E and English Province of Our Lady of Charity. So the main policy reasons, firstly, are control, that an organisation can and should be liable for acts over which it had control. Of course, that criterion had been fading in significance for some time, given the change in employment relationships. And as far back as 1967, academics were suggesting that control was neither necessary nor sufficient for imposing liability. The second policy reason is deep pockets, that an innocent claimant should be able to recover against someone and that an organisation is more likely to have money or be insured. Third is deterrence. This was the idea that an organisation who might be liable for the acts of individuals will take greater steps to reduce the risks, whether it's the hiring process, the disciplinary process, or its organisation of those employees. So, for example, whether a care home allows staff to be alone with children. Again, I mean, this factor isn't satisfactory in itself, because if deterrence was the main policy reason, an employer would presumably be able to defend themselves on the basis that they'd done everything that they could to prevent the act. That defence isn't available under common law vicarious liability, although as some of you know, it is available in relation to vicarious liability for harassment and discrimination under the Equality Act, and I believe also available under German law for vicarious liability. The fourth policy reason is loss spreading, the idea that organisations are insured. If they're liable, it spreads the risk across the insured people. That doesn't quite stand on its own because, again, vicarious liability doesn't depend on an organisation being insured. And fifthly, there's the idea of enterprise liability, that a business it's fair for a business to pay for acts where it's that business that created or exacerbated the risk of those acts. Now, despite significant developments in the law, there has consistently been a two-limb test which needs to be satisfied for vicarious liability. Firstly, the qualifying relationships test. Is there a relationship between the individual, the perpetrator in abuse cases, and the organisation, which makes it fair, just and reasonable to make the organisation liable. This was originally limited to a naked employment relationship, but has since expanded. Secondly, there's the close connection test, whether the connection between that relationship that I've just discussed and the abuse is close enough to impose liability. So first, the qualifying relationship. This is, as I said, this has grown from originally being limited to employers and employees to now allowing relationships to include those akin to employment. And the first growth of this was in 2006 in the case of Via Systems, where Lord Justice Ricks said that what one is looking for is a situation where the employee in question, at any rate for relevant purposes, is so much a part of the work, business or organisation of the employer that it is just to make them answer for the negligence. In 2013, the Court of Appeal in E's case that I previously mentioned thought that Via Systems had created a new category of vicarious liability, which applied to situations where there is no strict employee-employer contract, but which there is a relationship akin to employment. And Lord Justice Ward commented that to distill that to a single sentence, he said that it's that an employee is one who is paid a wage or salary to be under some, if only slight, control of his employer in his employer's business for his employer's business, whereas an independent contractor works in and for his own business at his risk of profit or loss. So that's the distinction there between a relationship akin to employment on the one hand and the relationship of an independent contractor on the other. Now, in the Christian Brothers case, the Catholic Child Welfare Society, the Supreme Court set out 5 policy factors, or incidents as they've sometimes been referred to, which, if they applied, would tend to suggest that it was fair, just and reasonable to impose liability in cases where there is no contract of employment. So those 5, as you'll probably all be aware, but I'll run through them quickly. 1 is that the employer is more likely to have the means to compensate the victim. 2 is that the tort is committed as a result of activity being undertaken by the employee on behalf of the employer. Thirdly, that the activity is part of the business activity of the employer. Fourthly, that the employer, by employing the individual to carry on the activity, has created the risk of the tort. And fifthly, that the employee is to some degree under the control of the employer. But in Christian Brothers, Lord Phillips explicitly said that those 5 policy factors or instances are not the same as criteria. And he went on to apply the sole criterion in that case of whether the relationship between the organisation, the Institute of Christian Brothers, and the perpetrator was sufficiently akin to employment. However, this distinction between the policy factors or instance and the criterion for establishing liability under this limb became blurred in Cox and the Ministry of Justice, and then in Armes as well. So we come on now to the Barclays case, which recently went to the Supreme Court. So this involved 126 claims by former job applicants and existing employees of a bank who alleged that they'd been sexually assaulted by a doctor who was engaged by the bank to carry out medical examinations of prospective job applicants. So at first instance, the High Court applied those 5 criteria, although they thought that the first and fifth weren't as important, and they decided that because of the way in which those 5 factors, particularly the middle 3, applied, they concluded that the vicarious liability could be imposed. In the Court of Appeal, the liability was also imposed. Lord Justice Irwin expressly stated that the question of whether an individual was an independent contractor was no longer the applicable test, and that there would be cases where vicarious liability was imposed where the perpetrator was an independent contractor. However, on appeal to the Supreme Court, as you will know, the Supreme Court concluded that this limit was not satisfied. Lady Hale held that the question was, and always had been, whether the tortfeasor is carrying on business on his own account or whether he is in a relationship akin to employment. And she said there's nothing in the Supreme Court cases, which is a bit of a stretch, to undermine this distinction. And the distinction, again, is between, on the one hand, independent contractor, and on the other hand, employment relationship or relationship akin to employment. And applying this test, the Supreme Court held that Dr. Bates was an independent contractor. Now, in relation to those 5 factors from the Christian Brothers case, Lady Hale said that they might be helpful in doubtful cases, but did not need to be applied at all in cases where it's clear that the perpetrator is an independent contractor. Lady Hale also briefly considered whether the law could be simplified by aligning the test for vicarious liability under this limb with the employment law statutory concept of worker under the Employment Rights Act, but she decided against it, saying that the tempting tidiness of such an alignment wasn't worth it, because the two concepts were developed for quite different reasons. My view is that this must be right. Context is important, and it's important to keep the two different tests. The employment context, the concept of a worker was developed in order to give that person more rights, whether it's the right to minimum wage or holiday pay, and their rights are based on that relationship. Whereas in tort context, one is looking for the liability of an employer for acts of the individual, and there's different policy considerations. I think for claimant lawyers, it's almost certainly a good thing that she chose not to align the tests, because in several of the cases which I've talked about, the perpetrator would not fall within the Employment Rights Act definition, and so there wouldn't be no vicarious liability. So the takeaway from Barclays, I think, and the approach that I think claimant lawyers should take, or courts should take, is first, carry out a factual inquiry to determine whether it's clear that there is a relationship akin to employment on the one hand, or clear that there is a independent contractor relationship. And this is basically an employment status test. You'd apply a multifactorial approach, including matters like control, mutuality of obligation, and integration. As Lady Hale explained, the key will usually lie in understanding the details of the relationship. So, in employment cases, that can extend to things like what uniform they wear, tax relationship, where they work, when they work, a huge range of factors. I tend to find that in employment cases that a quick rule of thumb to help with this can sometimes be that, and this applies more in business cases than voluntary cases, but if you imagine the perpetrator handing out business cards, firstly, can you imagine the perpetrator handing out business cards? And second of all, what would be on it? Would it be just their own name, or would it be the name of this organisation? So for example, I think in the Blackpool case, which James will talk about, that scout would have had the football club's name on his business card, whereas in the Barclays case, it seems likely that the doctor would have just had his own name on his business cards. Should also state that it's clear from the employment law sphere that the court just won't just accept that because it's written in a contract or somewhere that someone's an independent contractor, that's enough. It will look at the reality of the relationship. And that's been the case ever since the Supreme Court decision in Autocleanse and Belcher. So first of all, apply that test, look at whether it's clear either way. If it is clear, don't apply the 5 factors. If it's doubtful, you can apply the 5 factors. And in abuse cases, I think there will often be doubtful cases. So whether it's the scout or a lay religious appointee, a foster carer, an agency worker, I think in a lot of abuse cases, those 5 factors will still be applicable, but it's not the first test and it's not the only approach. The key approach is still, is it akin to employment? And so as I said, I think in my view, the judgment returns to being an employment status one under this first limb. 1 second, sorry. Just drinking out of my massive vase of water. Under the second limb, so that's the first limb, is akin to employment. The second limb is about close connection. And as you'll all recall, and I won't go through at length, the law has developed over many, many years. Originally, at least in the 20th century, being that vicarious liability required that the act was either authorised by the employer or was an unauthorised way of doing something authorised by the employer. This, of course, posed significant challenges in abuse claims because such acts were almost invariably unauthorised, and in fact not even an unauthorised way of doing an act authorised, particularly with regard to sexual abuse. It might be different if it was extreme punishment or something in a care home, but in sexual abuse cases, nothing like that was authorised. Then, as you'll know, in 2001 came the Lister and Hesley Hall case, where the House of Lords widened the scope of vicarious liability, saying that it could be established if there was a sufficiently close connection between the nature of the employment and the tortious act. That test, close connection, the House of Lords later said clearly did lack precision, but that was inevitable because the crucial features would vary. And in the Christian Brothers case, Lord Phillips remarked on this and said that a strong causative link between the relationship and the act was needed, but also that the creation of risk was not a definitive test, but was one of the criteria. So then we have the 2016 case of Mohammed and Morrisons, the unlucky supermarket who's been involved in two vicarious liability cases in the last 5 years on entirely separate things. This was about an employee who punched a customer, I think at a petrol station. And the question was whether they were liable for the assault. Lord Toulson gave a lengthy judgment, which I'm not going to go into in detail because in the most recent case, it's been suggested that this has been widely misinterpreted. So I'll talk about how they've more recently, how Lord Reid's most recently framed it. But what Lord Toulson said, that in its simplest form, close connection required A, identifying the field of activities, and B, looking at the closeness of connection. So then the Morrisons case, most recently the Supreme Court case, was a case where, as you'll remember, the employee published personal information of thousands of Morrisons employees online. He was motivated by a grudge against the company, and claims were brought which rested on vicarious liability. Lord Reid said that he was giving a proper interpretation of the case of Mohammed, but arguably reinterpreted it and said that the correct approach was identify the field of activities, and then secondly, identify whether the wrongful conduct was so closely connected with that field of activities that it's fair to impose liability. Lord Reid held that temporal and causal connections are not sufficient, although they can still be relevant. Crucially, he held that motive could be highly relevant. And actually, in this case, it was one of the key things because they said that the employee was motivated by acting for purely personal reasons, a vendetta, and that creation of risk is not sufficient was reiterated. And again, the distinction that remains crucial is the employee on the one hand furthering his own employer's business, however misguidedly, or on a frolic of his own. Crucially, and I'll wrap up quickly, crucially, although this might concern claimant lawyers and abuse claims because it makes it very difficult to find vicarious liability because motive will almost always be for purely personal reasons in sexual abuse claims, Lord Reid specifically carved out an exception, saying that a more tailored version of the close connection test should be applied in sexual abuse claims, and specifically observed that what one might look for is things like the employer's conferral of authority on the employee over the victims. So I think that allows for claimants in sexual abuse cases to emphasise the authority provided by the employer to a perpetrator, whether that's a teacher, a care worker, or a religious figure. And that point is further bolstered by what Lord Reid said about Bellman, which was a managing director assaulting a subordinate. So I think that defendants are going to try and rely on Morrisons to emphasise a restrictive approach, but claimants can still rely on that carve out and say that sexual abuse claims are different. That's it for me. And now over to James Counsell QC to discuss two of his recent cases. Thank you.
Thank you very much, Paul. And thank you also, Patrick, for your contribution at the beginning. So how did the courts apply those vicarious liability and limitation issues in two recent cases, BXB and Watchtower and DSN at Blackpool. First of all, briefly, the facts of each. BXB against the Jehovah's Witnesses. BXB was a woman of 29 at the time. She was raped by an elder in her Jehovah's Witnesses community after a morning's work evangelizing with the elder and their respective spouses. She didn't initially report the abuse for all of the usual reasons. When she found out that he had also abused a 14-year-old girl, she reported both of those instances of abuse to the elders, who took very little action before, apart from requiring her to repeat her allegations in the presence of the abuser. Eventually investigated by the police, and the abuser was convicted of offences against BSB and the other girl and also others. Civil claim issued in 2017, so 24 years after the primary limitation period expired. So usual issues: limitation, vicarious liability, and also causation and quantum. In arguing that the claim should be time-barred, defendants said, look, there would have been other witnesses we would have called if the claim had been brought earlier, but they'd now died. DSN and Blackpool Football Club. In June 87, DSN at the age of 13 was sexually assaulted whilst on a boys' football tour of New Zealand by a man called Frank Roper, who was working as a scout for Blackpool. Roper was aged 50 at the time, and he died later in 2005. Unknown to the club at the time, he had 4 separate criminal convictions for indecent assault on young males, the most recent, in fact, being only 3 years before the abuse. He had abused many other young footballers, both on that tour and during his time at Blackpool, many of whom gave evidence at the trial. As a result of that abuse, DSN suffered from psychiatric injuries and psychological problems. Sadly, also often the case made worse when he finally had the courage, prompted by others doing the same, to report the abuse to the police much later in 2016. So the claim was 22 years outside the primary limitation period, as you've heard from Patrick. Both cases tried late last year and early this year ended up in success for the claimants at trial. So let's see how the court dealt with both limitation and vicarious liability. First of all, limitation. 2 principal issues, as you've heard: reasons why there was delay and prejudice. In BXB, the judge, Mr. Justice Chamberlain, accepted BXB's reasons: feelings of humiliation, upset and shame, a feeling that she wouldn't be believed if she raised the matter again, having tried to raise it with the elders. The judge said that didn't amount to a psychiatric disablement, but that didn't matter. That wasn't necessary for the reason to be advanced as a good one. Went on to find that the cogency of the evidence was not so affected as to prejudice the defendant. He said it was difficult to see how the evidence on matters would have been significantly different had the claim been brought in the early 1990s. That's paragraph 128. No significant prejudice, therefore, and the claim was not limitation bar should be disapplied. DSN, Mr. Justice Griffiths, also concluded that that claimant had good reason for not bringing the claim earlier. The usual reasons, of course: he was 13 at the time, quite unable to tell his parents what Roper had done to him whilst on tour, fearful he wouldn't be believed. It would have spelt the end, he feared, of a promising football career. Kept his feelings of disgust, shame and self-guilt to himself for very many years, and as has happened so often recently, it was only when the Jimmy Savile scandal broke that he came to realise that others had suffered as he had, and that he would be believed if he revealed what had happened. As with BXB, Griffiths J concluded that practical purposes disabled didn't mean a psychiatric condition. It could be satisfied by any number of other things, such as those which existed in DSN. And whilst the club contended that the delay had caused prejudice, having heard the evidence, the judge concluded that there was no real possibility of significant prejudice, the established test, of course, if he allowed the claim to proceed. Witnesses had died, including Roper himself, as well as the club's youth coach, but the judge was satisfied that they wouldn't have contradicted the evidence which he'd heard. Crucially, he described DSN as being a transparently sincere and honest witness. He heard from a large number of other witnesses, those involved with the club at the time, almost all of them, in fact, apart from the youth coach, the chairman, the manager, the chairman, the club secretary, as well as many others who'd either been abused as young players or who had witnessed others being abused and had escaped Roper's attentions. Just pausing there, we've heard about limitation. It's really important to note, in my view, that cogency of the evidence is the key to success on limitation for a claimant. To illustrate that point, contrast DSN, where the claimant was successful, with the claimant in EXE and the governors of the Royal Naval School. That was a decision heard by the same judge, Mr. Justice Griffiths, only a few weeks after DSN. Judgment, in fact, was handed down on the same day as DSN. EXE was a 14-year-old schoolgirl who began a relationship with a school porter. Unknown to the school, the porter had a number of previous convictions, including for sexual offences on young girls. The same judge was not able to accept her evidence, not because she was telling untruths, but because her memory couldn't be said to be reliable enough when contrasted with other evidence from the medical records and the like, and also from witnesses, including her father and her sister, who gave evidence at trial. So because of that lack of cogency, the judge was not able to disapply the limitation period in that case. And similarly, in FXF, Mrs. Justice Lambert, in the Ampleforth case, came to a very dissimilar decision for the same reasons. The key, therefore, is preparation, as Patrick said, in the claimant's case. Checking and rechecking the witness statement against inconsistencies in the medical records and in other statements, especially if Professor Maiden is the expert instructed by the defence, because you can bet that if there are any inconsistencies there, he will spot them and they will be put to good use, and the damage may be done before you've even gone into court. So that's limitation. Vicarious liability, first BXB. Defendant maintained that the rape had occurred in the context of a friendship between these two couples. It was unrelated to any formal activity being undertaken by the claimant or the elder. Chamberlain J rejected that. He held that both key tests were established. The elder was carrying on activities as an integral part of the defendant's business activities, and the commission of the rape was a risk created by the defendant when it assigned those duties to the elder. In DSN and Blackpool, as to the first limb, you've heard about from Paul, the relationship between the club and the scout, whether it's close enough that it was capable of giving rise to vicarious liability. The court heard that whilst Roper was not on the books as an employee of the club, he might not, in fact, have had that business card that Paul talked about. He ran a youth team called Nova Juniors in the South Manchester area, which was an important source of recruitment of boys with the talent to go on up through the ranks at Blackpool. Two of those boys he'd recruited, Paul Stewart and David Bardsley, when subsequently sold for six-figure sums, saved the club from financial extinction. Paragraph 159 of his judgment sets out all of the reasons. As to the second limb, connection between that relationship and the abuse, was it close enough to impose liability? Connection between the relationship between the club and the abuse, club and Roper on the one hand and the abuse on the other. The tort in New Zealand was arranged after a meeting at the club social club, at which all parents attended and at which the club manager had spoken in support of the tour. In New Zealand, Roper was the only adult on the tour, apart from some young Blackpool apprentice players who'd come along to help out. One evening after training, he took the opportunity to abuse DSN, the last boy which he would otherwise have dropped off from the minibus, which was being driven by Roper. The parents, said the judge, only allowed Roper to take their sons on this tour because they saw it as part of a Blackpool FC recruitment operation, offering the boys the prospect, if they were good enough, of finding an opening at Blackpool FC. The full reasons are set out, as I say, in paragraph 159. So that's how the courts have recently looked at vicarious liability and limitation period. I want to finish with a couple of other, what I think are important learning points, which come out of the DSN decision, in fact. There are two judgments in DSN. The first, the main judgment, and then there's a cost judgment handed down a week later on the 20th of March. It's at 2020 EWHC 670. First of all, what stance should the defence team properly take in a case where it simply doesn't have the evidence to gainsay the account of the abuse being given by the claimant, and in DSN's case by a number of other witnesses? Roper, of course, was dead and hardly likely to have been called as a witness even if he'd been alive. But the defence had declined to make any admissions about the abuse itself, preferring in the pleadings to put the claimant to proof. The club's lawyers had ignored a request made by DSN's lawyers in the run-up to trial to make its position clear so that witnesses, not just the claimant but others who were being called, could be reassured that their account was not to be challenged. The club's lawyers had refused to do that. Had simply ignored the request. The judge was highly critical of that stance. He said, "I've noted that he was not cross-examined on the basis that he was not abused, but no indication was given to DSN or any of the witnesses who bravely gave evidence to me of abuse by Roper in a case which they had no personal interest, that they would not be cross-examined in that aspect until I asked for clarification myself. I was told that Blackpool had not responded to previous inquiries about that in correspondence, and I've been shown the correspondence. It's well known that for many witnesses, the anticipation of the ordeal of having to attend court and be cross-examined on painful matters can be greater than the ordeal of cross-examination itself. DSN was not spared that ordeal of anticipation." And he was, as I say, went on to be critical of the club for that. So you may like to consider writing to the defence, citing paragraphs 188 and 189 of the judgment of Griffiths J and DSN, and inviting the defence to review its pleaded case on abuse, or at the very least to indicate that it won't be challenged, and making it clear, of course, that that open letter will be referred to at trial if the defence decline to do that. Second important point is costs. Again, the judge was very critical of the stance which the club adopted in relation to settlement of the case. In fact, he made an indemnity costs order anyway because the claimant did better than a Part 36 offer made before trial. But he also made an indemnity costs order from a much earlier date because of the way that the defence had failed to engage at all in settlement negotiations. The judge's judgment makes clear that any defendant who simply refuses to engage in ADR on the ground that it's confident that it will win risks cost sanctions. And he said this in paragraph 28 of his cost judgment. Experience has shown that disputes may often be resolved in a way satisfactory to all parties, including parties who find themselves able to resolve claims against them which they consider not to be well-founded. Settlement allows solutions which are potentially limitless in their ingenuity and flexibility, and they do not necessarily require any admission of liability or even a payment of money. That's, as I say, paragraph 28. And so again, you may think that it might be worth putting a bit of pressure on the defence, perhaps by inviting them to take part in ADR, perhaps the vehicle being the usual direction in the CMC directions, that the parties must engage in ADR, and if not, file a statement explaining why not. And you may think it's helpful to refer them to those passages from the DSN cost judgment in your letter. The message is just because the defendant thinks it has a strong case is not a good reason for not engaging in some form of ADR. Well, ladies and gentlemen, that's all I'm going to say on those two cases. I hope what you've heard from us is useful. We've got a few minutes now, and I hope that Paul's going to tell us that somebody may have asked a question in the chat, or if someone has a question now, then perhaps they'd like to unmute themselves and put themselves on the screen if they would like to, and ask us any question that you would like. Thank you very much.
Thanks, James. We've got at least one question, and I've also got some questions if there's no others. One question from Gary Walker. This is for Patrick about limitation. So the question relates to the tests applied in cases where the allegations aren't about sexual abuse. And so he says some of the football claims which relate to physical and emotional abuse and bullying, etc. they're facing defences which avoid dealing with prejudice, but instead concentrate on the fact that these are allegedly relatively minor allegations of verbal and physical abuse. And they argue, therefore, that absent serious effect, that the court shouldn't apply their discretion. Patrick, do you know of any helpful case law to address the objective seriousness of the abuse, or do you have a view on how a court might address this?
Gary, this isn't what you want to hear, but at the moment offhand, I can't think of cases. I do, though, think the court still has a cultural issue with this type of abuse, and that proportionality is a sort of backdoor way of getting out of these cases, and that shouldn't be the case. But it does come down to being able to get the sort of evidence that reflects the impact of that type of abuse, the belittling abuse that we all know of, and how constant that can be and how damaging that can be. It's so dependent still on the medical evidence. But it's an interesting point because it does come up regularly, and it's strange how the courts don't have a handle on how damaging that sort of abuse can still be. But they need the evidence, I suppose, is what it comes down to, of the consequences. That's my limited, rather unhelpful answer to your question. But I would
Can I just add a little bit to that? I think it does rather depend on what the abuse is. I've got a series of cases where I'm acting for claimants against another football club where they were subjected to racial abuse, so not sexual abuse. It just depends how serious it is, doesn't it? And obviously it's more difficult if as in the Nugent Care case, the abuse perhaps was relatively minor. But I don't think one should give up on the fact that abuse of whatever kind is very serious, particularly for a very young claimant. And the courts will need to take cognizance of that. But I think it's a very good question you raise, Gary, and a really difficult one outside the realm of specifically sexual abuse. Thanks very much, Gary. Nice.
I'll just add in here, if that's okay. And I think that, as lots of us will be aware, there can be a tendency for people that are sort of unfamiliar with how trauma works to think that there is a necessary correlation between the seriousness of the abuse. So if you're seriously sexually abused, you will be completely traumatized and your life will be ruined. If it was not serious acts, then you should be fine. And we just know that that's not the case, that our understanding of trauma, or at least the medical understanding of trauma and psychological understanding of trauma, has developed pretty significantly away from that. And so I suspect it's going to be a case for expert evidence, really, as James says and Patrick says, and not just letting people assume that the severity of the abuse necessarily correlates to the impact on that individual.
And Gary, very quickly, sorry Paul to cut across you, but very quickly, one of the catch-all cases in this type of situation is the Pearson Doncaster case, which you will know about, where there's very little psychiatric evidence available, but there's just the fact of what happened to the young person in foster care. And it's a good case to use as a reference point in these types of cases, it seems to me.
Thanks. One quick question for James from me. Do you think that there has been too much of a focus, or there is too much of a focus on the consistency or inconsistencies in a claimant's evidence in the context of limitation, given what we know about the reasons for inconsistencies, whether it's the fact that they were in care and there's lots of records, or the fact that we all have faulty memories, or the particular vulnerabilities? So do you think that there can be an overemphasis on that sometimes?
Well, certainly I wouldn't think that in the light of DSN, but I would think that in the light of EXE, unfortunately. It's a difficult one because, of course, as Patrick told us, the judge has to deal with limitation first. And so one of the main issues that he's going to be dealing with at the beginning of his judgment is the issue of cogency, and it's bound to form a very large part of what he then goes on to decide. And of course, in FXF, frankly, it was the be-all and end-all because the judge didn't deal with the rest. So I'm afraid it does it does become very important. And it is so important, as I've said already, to make sure that any inconsistencies which can be avoided in the claimant's account are ironed out before witness statements are exchanged, because if it's done too late, it's going to be too late. It is an important point arising out of the way in which the judge has to approach giving judgment. Well, I'm wondering whether there's any more questions from anybody. We've got no more, I think. So just gone 1 o'clock, and we hope to finish this little webinar by 1 o'clock, and we almost have done. It's been really good to see everybody, or rather see everybody's names at least, for most of you. Lots of really familiar names. I think, speaking for myself, but I'm sure Patrick and Paul agree, this has been a very enjoyable hour or so actually doing this exercise, and maybe we'll do it again. Do give us some feedback. We'd very much like to hear what everyone has to say, and thank you very much for giving up an hour of your time to join us. And if you'd like now to click on the bottom of the screen at the bottom, which little red button saying leave, thank you for coming, and see you all again soon.
Thank you very much. Bye, everyone.